Brian Parker here. I'm going to take you through an interesting approach you've heard me talk about the Green versus PRA case. Fascinating case that is going to just rock this work in that it lays out every possible angle of a debt buyer buying a debt it doesn't own and can't prove it owns. And the person in that case, it's Green versus PRA, Miss Maisie Green, on her own against two huge law firms, broke down exactly why PRA or any debt buyer doesn't own the debt. And the court enunciated even better, elaborated on every step that has to occur for an assignment of a debt to go from the creditor to the assignee and then the now assignor to the assignee. And the requirements are, you got to have an account number, you got to have the actual name of the debtor, you've got to have all the information every time the debt is assigned. So we're going to kind of go look at this new case, a case I just recently answered and filed through the prism of the Green versus PRA case. And here we go. So we're going to call this video show notes. This show notes are for the assignment of Cross River Bank on a debt to nowhere. Let's see what we can do. And the underlying title in reference to the chain of title, we're going to call it Good Luck With That. Here's why. This loan was a client of mine came to me saying she's being sued by a company. It's a new one for me, HS Financial Group LLC. It's out there now, and they are claiming in their complaint, in fact, let me put up their complaint, Shazam, and you'll see right there, and I'll read this. At the very beginning, this is rare, but at the very beginning, they say Plaintiff HS Financial Group LLC, HS Financial, is an assignee of Cross River Bank. So what does that mean? An assignment means you're going directly from point A to point B, meaning Cross River Bank assigned the debt to HS Financial. So let's see if that's true. In the complaint at paragraph 5, let's put up that first part I just talked about, Plaintiff HS Financial Group, Shazam. Just that little sentence. And now take that away. And now let's put up paragraph 5 of the complaint, Shazam, and you should see very clearly, it says the obligations of defendant to Cross River were sold and assigned to HS Financial under a bill of sale, a copy of which is attached as Exhibit B to this complaint. Remember that, all right? Paragraph 4, so let's get rid of paragraph 5 if it's still up, swish, and then paragraph 4, boom, shaboom, shazoom. Says defendant accepted the financial services provided by Cross River, but has failed, refused, and neglected to pay Cross River in full. Well, if HS Financial has this debt, I don't know how they can say something representing Cross River. And it's a loan, it's a note, as you will see real quickly. There's no financial services. Financial services is you go to a financial services person and said, check out my finances. This is just a loan. So this is all wrong from the get-go, literally in the beginning where it says, we're an assignee of Cross River Bank, as you shall see. Now, the prism that you look through, I'm doing a lot of this today. The prism you look through again is there an assignment for there to have standing? You must have standing to sue somebody. So if we look at the complaint as we did, they say go to Exhibit B. So let's go to Exhibit B. But before we do that, I want to see one thing. Let's put up the actual first page of the note, Shazam, and you'll see I've circled April 5th, 2018. Remember that date. So your analysis, I'm going to take you through this analysis. I want you to do this analysis on your own debt buyer case when you look at bill of sale. That's what today is about. I don't just sell you a piece of paper. I want to sell you instructions. I want to give you the means to analyze these things. Very simply put, I'm a simple person, truly. And so I'm going to take you through this the way I did this case, actually. It's another case that I did on an assignment. And again, Green versus PRA is the Prism. You can just go to my membership website and find that, or just Google it. So remember, April 5th, 2018 is when the debt was started. And we don't need the complaint anymore. The complaint will be attached to the video on my collectionstoppersolutions.com membership site. So they're telling us we own the debt, just go to Exhibit B. So go to Exhibit B, and the first one, and I put the number on Shazam, number 1. That's Cross River Bank. Okay, so they're right so far. So this assignment should say Cross River Bank to HS Financial. Whoops, no it doesn't. It's going to, or from, or with a Monsenite LLC, also a Wilmington Savings Fund Society, FSB, as a trustee of Monsenite Trust. So it's a convoluted mess already. And here's the kicker. Look at the date on the bottom of the bill of sale master loan assignment. It's 8/21/17. This is their proof that my client owes this debt to HS Financial Group. And they said, look at B. We looked at B. Here's B. Here's B. Look at that. 8/21/17. That's 8 months before my client initiated the debt I think we said April 5th, 2018. So far, ain't there. So maybe we'll give them a little bit more benefit of the doubt. We'll look at the bill of sale number 2, Shazam. And this is June 29th, 2018, supposedly. And it's a bill of sale again. It's claiming Wilmington Savings Bank Society, FSB. We don't know how they got the debt. Or Monsenite Trust, a New York law firm trust. And anybody else? Anybody else? Credit Suisse Finance LLC, Paul Lees, claims that the Schedule 1 attached is, I guess, sending my client's debt to all these other entities. There is no Schedule 1 attached to this. Also, here's the fun thing. If you look at the bill of sale, third line up from the first paragraph, bottom of the first paragraph, without recourse and subject to the conditions of the agreement, which is, they always have like a master agreement. They have a master agreement here, which they never attach. They cannot let you see that. But everything is done pursuant to that master agreement. So you got to see it. If you're going to prove to me you own the debt, so far you don't. But I put the word none on the bill of sale because there is no Schedule 1. And without recourse essentially means, here, you take this. You can't sue us. You're taking this debt. Hands off. You can't sue us. Well, think about that. Why are you telling someone that as you sell them something? It's like selling a car as is, and you know the brakes don't work. You just go, sorry, without recourse. That's what they're doing. So if you're selling something as is, chances are it ain't very good. So that's the bill of sale, supposedly, that's transferring all debt. But wait a minute. There's more. Nowhere in the bill of sale is your client, your debtor, my debtor, mentioned in this bill of sale. Just a little oversight. Well, I mean, if it is part of the chain of title, they say go to Exhibit B of the complaint. It should be there. It isn't. Wilmington Savings Bank hasn't signed it. One of those Monsenite LLCs hasn't signed it. It's a riddle that they even put this up. But as the Green case says, 90% of these things just get defaulted by not answering. You're a disciple of my videos. You answer. And of course, don't forget the counter affidavit. So the next bill of sale is Credit Suisse. And it's a convoluted mess again. A trust and a depositor. And now we have what's called an issuing entity in that first paragraph. Let me do this. Sorry. Shazam. That's the bill of sale. That's number 3. And that's a convoluted mess too. And of course, Schedule 1's not attached. And of course, my client, the debtor, is not mentioned. And you have to have that if you're going to assign. Remember at the beginning of this video, I mentioned Green versus PRA. The court held, after looking at all the nationwide assignment cases, they came to an honest conclusion, which if it's not attached with the account number and the person's name, then you're not selling this person that you're suing. You're not suing their debt, regardless of whether she owes the debt or not. And this one's only signed by Credit Suisse, even though there's 3 other entities and my client, the debtor, is not mentioned. Here's the fun one. Ready? Here's the fun one. This is where the just goes off the cliff. Look at bill of sale number 4. A Grassy Spring, Shazam! A Grassy Spraying Group, Inc. as seller is hereby absolutely, not just selling it, he absolutely sells, transfers, assigns, sets over, and conveys to Recover Exchange LLC. And now here's a good one. Without recourse and without representation or warranties expressed or implied of any type, any nature. If you're trying to get rid of something, you can't get something, a piece of shit debt, off your balance sheet any better than without recourse, without representations, without warranties, express or implied or any type kind of nature. Just get it away from us. It's a fish that just smells worse every day. Here, you take it. That's one thing. So if you're selling a thing like that, it's worthless. But who the hell is Grassy Spraying Group? Where did they get the debt to pass the debt on that isn't mentioned in my client's, without my client's name, without their account number, no Schedule 1, no computer file, as they say, is attached and sold and signed by Grassy Spraying Group. Where do they get these friggin' names? But in order for Grassy Spraying Group to sell anything, it has to be an assignee. There's no reference to Grassy Spraying other than when they're being an assignor. So that dog ain't gonna hunt. That's off the rails right there. Go to number 5. So they sold, Grassy Spraying sold something it doesn't have to Recovery Exchange LLC. Number 5, Shazam. And that's another bill of sale from Recovery Exchange, who received from Grassy Spraying something Grassy Spraying didn't have the right to sell, but whatever they sold has a bunch of fleas and really smells, and we don't want anything to do with this. But Recovery Exchange, they sell it to Southern Capital Finance Group, as you can see, and that's on June 9th, 2021. And they have the made without any representation, warranties, or recourse. So even Southern Capital or receive this dog is just giving dog fleas and all to this company, Southern Capital Finance Group. So no representations, no recourse. They're all passing this dog bleep all the way down the road. So then Southern Capital Finance Group, finally, number 6, Shazam, sells this to HS Financial. Now, I'm not being picky here. This is significant. You'll notice that all these companies in these exhibits have their full name. Southern Capital Finance Group, LLC, is selling, by the way, it's selling the stuff it got from Recovery, which it got from Grassy Spraying that had nothing to give. But whatever it gave, it smelled. And now they're selling it to HS Financial. This is the first of 6 bill of sales that have a shortened name or a colloquialism as in HS Financial as the purchaser. What am I saying? This isn't even HS Financial Group. But what your HS Financial Group did is in the complaint, changed its name to HS Financial. Why? Because HS Financial is probably a different company from HS Financial Group LLC. And they're just trying to pretzel their way into this complete mess. So a bill of sale must have your full name. Otherwise, the company that is claiming to own this dog thing can't say they own it. So you must, just like all the other companies that put the LLC, HS Financial for some reason didn't here. So it's probably even a separate entity that they received when they received nothing. So, conclusion. HS Financial Group LLC, at the beginning of this, says, we're an assignee of Cross River Bank. Not true, as I just showed you. In fact, the only thing that HS Financial Group received is, well, it says here, absolutely nothing. Why? Because they never received anything. If you want to break it down to its minimum, the whole thing died with grassy spraying. If you can show under Green versus PRA or any Michigan, Florida, Wyoming, whatever law as far as regarding assignment, that the debt and the debt account number of your specific debt pass between all these entities. I think there's like 10. That hasn't happened. And even the final one where HS Financial is going to go, we own this debt. It isn't even their name. And they received it on a dead assignment from grassy spraying. I hope you can see that. It's pretty cool. And that's how I analyze these things. They're complete you don't put that in your pleadings, but you can say it legally. And you certainly do say it legally in your counter affidavit. And as like I always counsel, break down their paperwork like I just did and use their paperwork against them. So what is my mantra? That's right. Use their own paperwork against them. And this is an analysis of a bill of sale that you can use. So when HS Financial Group LLC is claimed to be an assignee, they're full of beep, and they're not. Good luck winning this case, HS Financial or HS Financial Group. You ain't got nothing. But you, my friend, my member, my viewer, have everything. Go grab this and rock and roll and beat these guys. Thank you. Oh, like, love, subscribe. Let me know I'm doing the right thing for you here. Go to my membership site for all the solutions with the paperwork. So if you go there and you've got a debt with UHG is suing you, I've got UHG videos, answers, counter affidavits, show notes, everything attached to that video for probably under 40 bucks, something like that. It's really silly how little I charge, but those are launch prices right now. I'm going to be upping them soon. But everything you need. And always remember my mantra after you listen to the first mantra, which is, that's right, use the paperwork against them. And an even more important mantra is, that's right again, good job. Counter affidavit country, baby. No matter what the state, add your counter affidavit with all this analysis, with all their paperwork, and then you can rock and roll. Now I'm going to let you go. Sorry to keep you, but I hope this is helpful. Like, love, subscribe. Thank you very much. Bye.